Hello, everyone. Good morning, good afternoon, good evening, good night. I'm Amanda Ashley, one of the attorneys here at Altitude. Thanks for joining me, Legislative Update. I have a couple of things I have to read to you, which if you've attended these before, you know is the usual. So on your screen, you should be seeing a little box with me in the corner. And then you should see the rest of the presentation. There's also a private chat icon. If you have questions, feel free to put them in there. I will do my best to answer them as we go. I will also, for any leftover questions that we don't have time to get to, I'll do those at the end if we have time. If you have audio or video issues, don't tell me because I can't do anything about it. As you know from when I've done these before, I have a master, a wizard who is behind the curtain. That is Courtney. Courtney is available if you have technical issues or you want to complain about the presenter, for example. Just let Courtney know, email Courtney, call Courtney, put it in the chat. She'll get back to you. Let's see, manager classes. I don't know if we're having CMCA credit certificates for this one. If we are, then that will be sent to you later. You'll want to save it in the email. The presentation will be recorded and pop up to Altitude in a few days. And of course, there's a survey at the end that will pop up if you have any feedback. If it is good feedback, please let me know. If it is not good feedback, be gentle. I'm very sensitive. But seriously, let us know because we want to improve and we want to do better, right? Because of what y'all to attend. So 2026 legislation. What we're going to be talking about today, if I can get this to work, I might already need Courtney's help and we haven't even started, is that we're going to be discussing the legislation that passed. She is going to have to help me because I can't even get this. There we go. So today's agenda. So we're going to talk about the legislation that passed this last session. There actually weren't as many as we've seen in prior years, which is good. It makes me a little worried about what's going to happen next session, but that's okay. So I'm going to talk about winners. I'm going to talk about some of the losers, and then I'm just going to talk about kind of general speculation type of things, and we'll do questions. The reason I'm talking about winners and losers is not because I want you and everyone who's listening to be confused about what passed and what didn't, but because we're likely to see some of these come up again. Usually if something has gone through and it didn't pass, or it didn't, even if it gets vetoed by the governor at the end, we often see it pop up in some other fashion, maybe with a few tweaks later on. So that's why I talk about those. The ones we had this year, housing development continues to be a big thing, insurance, housing protection, etc. And then, like I said, we'll get to the losers. So the winners. Of course, I put my little jokes in here mostly to keep me entertained, but hopefully you guys think it's funny too. So when it comes to the winners, one of the first ones we have, and I did these in numerical order. Sometimes we group them by topic, like we'll do all the insurance bills or we'll do all the housing bills. I did it by just in numerical order. I don't know if you find that helpful or not. If you do, let me know. If you don't, let me know. At any rate, HB 26-1001, Housing Developments on Qualifying Properties. This is also called the Home Act. This is set to take effect December 31st of 2027. It is an affordable housing bill. It applies to subject jurisdictions, and the purpose is to assist with the housing shortfall and to create more affordable housing. The bill is meant to streamline construction of residential developments on qualifying properties. So basically what it's doing is it's implementing an administrative approval process. The purpose being is that the legislature said that because things are taking too long to build, and I'm paraphrasing, they probably didn't use that exact language, that they have decided we need a statewide solution that limits the construction, a statewide solution to local government policies that limit the construction of housing in areas that are served by infrastructure, because that's creating housing supply shortfalls. So this bill addresses local zoning regulations. It's intended to streamline construction of affordable housing by implementing this process that allows residential developments to be constructed on qualifying properties as long as they meet certain criteria, certain requirements. The purpose, of course, being more housing equals more affordable housing. I don't know if that's true or not, but I certainly hope so. So what the bill does is it, like I said, streamlines the process to reduce housing construction costs. And what it's going to do is, remember that word subject jurisdictions. We've had that come up what started a couple of years ago with like ADUs, right? Accessory dwelling units, where we have subject jurisdictions. So cities and municipalities who meet the definition of subject jurisdictions basically are going to be allowed to determine site design standards for residential development. So it's going to be an administrative approval process where they can go in and if it meets these requirements that they apply, for example, to other residential developments in the same jurisdiction, then it would pass through. It does not apply to certain properties. There's exempt ones, right? So properties served by wells, septic tanks, conservation easements, industrial use. But it does apply to qualifying properties. And qualifying properties are those properties that are no more than 5 acres of land, owned by a qualifying entity, such as a school district or a nonprofit that does affordable housing, and within one of those subject jurisdictions, which is a municipality, or within a county with a population of 5,000 or more. So on or after December 31st of 2027, subject jurisdictions shall allow residential development to be constructed on these properties subject to an administrative approval process. Now, you may be asking yourself right now, why do I care about this, Amanda, and why are you telling me? Because when I go through these, and I sit on the Legislative Action Committee, what I do is on our website, I have us list bills that not only apply to community associations, but that also may affect us peripherally in some fashion. So, for example, with more housing, because of the very nature of our practice area, and I'm including all of you in that, we tend to have community associations. Colorado is a very community association heavy state. So that's why I include bills such as this, because ultimately it will affect us down the road, even if your association is one that at this point is well past this part of development. So this next one, and again, numerical order, HB 26-1007, improve customer use distributed energy resources, which is basically portable solar energy device. This one goes into effect this August, but the Kiowa amendments regarding energy efficient measures actually takes effect January 1st. And so what this is it talks about portable scale solar generation devices. I put a little picture in the corner, and those are devices that can plug in directly to a wall outlet to provide immediate energy to the home, right? So they're the smaller portable solar panels. A lot of times you'll see them like at campgrounds. If you're a camper or a glamper, you'll see these out. So those are kind of those types of devices. And what it is called is, or defined as, a single photovoltaic system, and its associated equipment that will supply a max power output of no more than 1,920 watts to the electric grid. Photovoltaic is just technology that takes the sun and converts it into energy. The device must include a feature that prevents it from energizing the grid during a power outage, and customers cannot connect more than one device to a single wall outlet per address under this bill. Now, this bill has some things for community associations and some things about utility providers. For the utility provider side, they cannot require the customer to obtain approval prior to the install. They can't require a customer to pay an additional or a fee related to the device or install anything additional aside from what's already contained within the device. But they can require notification that the customer is going to be using that device and the wattage size of the device. For associations, beginning January 1st of 2027, you will not be able to unreasonably prohibit or restrict installation, use, or operation of the device. Any covenant or restriction that does so is deemed unenforceable by a matter of public policy. Now, you'll note that this is actually going under 1067, so it's coming in as an energy efficient measure. I do have a small typo here. It is allowed on, you must allow them on limited common elements, not general common elements, although you can, but limited common elements that are adjacent to the owner, that are for the owner's exclusive use. You can require reasonable restrictions for installation, use, or operation of the device. You can require prior notice of the installation of the device. You can look to location and restrictions that are related to preventing fire or electrical overload of the existing system, or that could potentially harm or damage another person or property. Also, associations, you are not required to require, but you can require the owner to secure the device on the limited common element. The purpose being that if it's just sitting out there and there's a windstorm, we don't want it blowing over the balcony and harming someone below. So you can require that it actually be secured to the limited common element. Also, you can make the owner responsible for all liability and costs associated with the installation, maintenance, or removal of the device. So if they're placing it on a common element and you, the association, are telling them, no, we want it secured to the limited common element, you can also require, for example, a maintenance and indemnity type of agreement, or require that due to their installation, they have to remove it so that the association can maintain whatever part of the property it's on if the association is heading that way. So kind of like solar panels, when it comes to solar panels on roofs, where the association can say you're responsible for removing that if we need to maintain the roof. Very similar here. The owner responsible, liability costs, they can be required to indemnify the association. And then this bill also contains additional information about these things called meter collar adapters. So basically, when you read this bill, because I know you're all going to, because it's just fascinating reading, it talks about meter collar adapters. And what those are is on the outside of your, could be on the inside, but where your electrical box is. This is basically an adapter. It kind of works similar to a power strip in a way. So it's an adapter that goes around that connection so that you can plug the solar device in to provide energy to the home. Part of the purpose of this bill, again, we're looking at affordability, affordable housing, but also affordable energy. And so this is why this passed. So for those of you that, your solar policy is not a required policy under Kiowa. But for those of you that are in associations or have associations that have solar policies, or that have rules and regulations or architectural guidelines that reference improvements or things being placed on limited common elements, such as patios, balconies, and decks that are adjacent to a unit or adjacent to a residence, those are going to need updated. So again, you're not required to have that policy, but for those of you who have that policy, rule, regulation, guidelines, you're going to want to take a look and update those because it will need to comply with this bill. Okay. All right. Now, as you may recall, recently, federal disability housing protections were rolled back, so to speak, regarding service animals. And so Colorado said, well, what we're going to do is we're going to restore that federal guidance by codifying into state law what federal law was. So for practical purposes, you're not going to be doing anything different with this bill than you have hopefully this entire time, because the law had certain guidelines that you should have been following. But the gist of this bill is that you cannot refuse to make a reasonable accommodation if the accommodation is necessary to afford the individual with a disability equal opportunity to use and enjoy a dwelling, and that includes having an assistance animal. A reasonable accommodation is an exception to that exception or adjustment to a rule, policy, practice, or service that is necessary for the individual with a disability to have that opportunity. So for purposes of this bill, for example, if someone has a disability and has an assistance animal, then if you're in an association that either limits animals or that says no dogs, for example, and they have a service animal that's a dog, then this is going to apply. And so what it says is that an assistance animal, when it comes to housing, is presumed to be reasonable, and a complete prohibition of assistance animals is presumed to be discriminatory. The mere presence of an assistance animal does not constitute a direct threat to health or safety, nor is it presumed to result in substantial physical damage to the property. So a housing provider can request reasonable documentation supporting the claim of someone that they need an assistance animal. And a housing provider can also, instead of documentation, engage in a a conversation with them, and I would be careful with that because then there's nothing in writing, right? But what you can't do is just say outright you can't have the animal. The other thing, though, is if you do have a service animal that has documented history of conduct that poses a direct threat of health or safety, or documentation that they've caused substantial physical damage in the past, you can consider that. Okay, so again, this is just going to go back to service animals and codifying federal law and guidelines that were rolled back this year. Okay, 261099. This was probably the most applicable bill we're seeing to homeowners associations this year, in my opinion, which is always humble. And what it is it goes into effect August 12th of 2026 as well, so this year. And it does a couple things. First of all, it requires a declarant prior to turnover of control of the association to the owners, right? So a new development that hasn't quite turned over completely from declarant control. The declarant must obtain a reserve study. It cannot be from a friend or a pal. It has to be from an independent reserve study professional or other qualified professional with knowledge of industry standards for the reserve study. And the only business relationship that person doing the reserve study can have is the business of doing the reserve study, right? So the reserve study has to be done prior to transferring the control from declarant to the association. The study must, much like reserve studies in general, must address components of the common elements, property that the association is responsible for maintaining, repairing, or replacing pursuant to its governing documents, pursuant to the declaration. And the reserve study must project costs over a 30-year period, including projected costs of maintenance, repair, replacement of common elements or property of the association. Now, why? Because one of the concerns that the legislature seem to have is that when people buy into residential properties, they don't quite realize how much it may cost over time, right? So when you first buy in, you might say, oh, well, look at this, our assessments are $100 a month or something like that. Not realizing that the budget may not be set up to cover the projected costs of these common elements over, let's say, the next 30 years, right? And so subsequently what happens is people might buy in at an association at $90 a quarter or $100 a month. But then you have to have budget increases or special assessments as the life of the components wear out. So this bill initially started, it actually had a separate funding component by the declarant, and that was removed from the bill. So it ended up passing in this form where the declarant has to obtain the reserve study. In theory, because then when people buy in and when the association assumes control from the declarant, they will be better able to review the budget as it is currently at that time, and then adjust it accordingly so that you are funding your reserve over time to maintain, repair, and replace these elements, as opposed to some of you who end up in association that hasn't done that work and couldn't afford to do that work for many years and are now faced with significant budget increases or special assessments in order to try to retroactively go back and now fund a repair that should have been planned for years, right? Okay, so the bill also updates the disclosures. So the two things, it updates the section about the documentation and the audit of the documents and information that the declarant is required to turn over to the association under that audit provision. And it requires an update to the disclosures that the association sends out to owners each year. So in addition to any reserve study that the association may subsequently obtain, there is now a specific requirement for this declarant reserve study. Now, a lot of you are in associations already that have long transferred control from the declarant. In that case, you don't need to worry about this part of this bill. Certainly, you still are required to have a reserve study and investment of reserve policy under Kiowa, but you won't have to worry specifically about this declarant reserve bill. However, those of you who are in associations that have not completely transferred control from the declarant over to the association, this is going to apply to you. Now, this bill also updates the association records provisions to include this copy of the Declarant Reserve Study. So what does that mean for your inspection of records policy? As you know, or should know, the inspection of records policy is one of the 9 required Kiowa good governance policies. If your inspection of records policy is written in such a way that it includes a more general provision that says something to the effect of records available to owner, including all records under Section 317, well, then you're fine. On the other hand, if your policy does not have a general catch-all like that, then you're probably going to need to update your inspection of records policy to include something that either says also the Declarant Reserve Study or that says and all records available under 317. Now, the other part of this bill, which will apply to all of you that have, sorry, I jumped ahead, that have any type of management company currently or that intend to go from management company back to either board, self-ran board, or to a different management company, is this bill also has a provision regarding management company transferring of property over following an association canceling or non-renewing their contract. Okay. So what the provision says is it amends 317 to state that the management company has 45 days following a termination or non-renewal of a contract to turn over all association property, which includes money, financial accounts, account records, account books, financial records, insurance policies, contracts, documents, invoices, receipts, account information, passwords, etc. You have 45 days, management companies, from the time the association terminates or decides to not renew your contract to turn over all of that property to either the association or its new management company. Failure to turn over the property makes you liable as a management company to the association for things like late fees and interest that the association incurs because it did not get its information from you within that 45 days. So if they have to pay late fees and interest because they didn't have the passwords or they didn't have the information or they didn't have the books, you as a management company can be liable for that. You're also liable under this bill for any other damages incurred by the association that are a result of not receiving the property within the 45 days. And if you are found to have not complied with this section, you can be fined $250 per business day up until the day you turn over the property, all of the property. And if the violation is found to be willful, so you intentionally did it, then you can be liable to the association for treble damages, which is triple times the actual damages plus attorney fees and court costs. Now, those of you, and this is where I think we see it the most, that have ledgers, for example, where you have received a ledger and that ledger has a balance carryover for the owner from who knows when. When you go to turn those ledgers over, that's going to be an issue, right? Because the attorneys oftentimes need those ledgers from the association. The association relies on you as the management company to maintain those records. So please, it will behoove you to make sure you get all of that property transferred over so that you don't end up with this issue, okay? Now, there's also a question because it says 45 days in this bill. It says 45 days from termination or non-renewal of contract. And some of you have contracts with a management company that says you need to give them, 90 days advance notice. The bill doesn't really contemplate anything like that. It doesn't say 90 days from the date the contract ends. It doesn't say 45 days from the date the contract officially terminates. It says 45 days from the date the association terminates or does not renew the contract. The other part of this bill is it says you cannot charge the association. It says provide the association their personal property at no charge. Some of your contracts that the associations are in with our management companies provide for fees for turning over personal property. So I would recommend taking a look at that. Okay. SB 26155, an insurance bill. This is also a bill that addresses what is called home hardening. Hardening. What does that mean? I didn't know. I had to look it up. Home hardening is really has to do with things like resilient roofing. So roofing materials that are less likely to fail under extreme weather, under hail damage. They maintain habitability from the roof down. They have a lower, they're meant to withstand extreme weather with a lower capacity for things like the wind coming in and tearing them off. Okay. This bill, effective August 12th of 2026, and it is set to finance what is called a home hardening program through a fee imposed on insurers. Now, you would think, well, why would we charge the insurance companies when we know that insurance companies have been pulling out of Colorado? So here's what this is set to do. It creates what is called the Strengthen Colorado Homes Enterprise. And the board of the Strengthen Colorado Homes Enterprise is tasked in part with administering this fund and also in part with administering the grants that the fund is supposed to fund. Part of this is that they will impose and collect fees from insurers that are offering multi-peril insurance policies. Those fees go into this grant that is operated by this enterprise. That grant will go to owners, associations, property owners, etc., to build resilient roof systems. It also goes into developing a code of conduct for roofing contracts, training, and roofing protocols for roofers so that insurers down the road who know that you have a home hardened roof can be rest assured that it met these standards such that they can continue to insure. So, in theory, the fee that you're charging that the state is charging the insurer would then go back into replacing roofs with material that is designed to withstand more extreme weather, thereby resulting in less claims to the insurer, so the insurer would make the money on the back end, theoretically. Okay. The Strengthen Colorado Homes Enterprise Board is appointed by the governor no later than January 1 of 2027. And again, it's going to award the grants, impose and collect fees, administer the program. It's required to file annual reports, implement training and protocols for the roofing program, so on and so forth. So again, another insurance bill that is meant to ultimately try to reduce insurance costs for all of us over time. Okay? I hope that makes sense. All right, now we're going to talk about the losers. Now, again, remember the reason we're talking about the losers is because of reference purposes. Don't get confused and think, well, she said legislation highlights losers. That means they passed. These did not pass. I'm mentioning them because we're probably going to see them or similar ones maybe in the future. And this is going to go a little quicker. We'll see. Okay, so here are some of the bills we saw come through this year that ended up not making it in various forms. Some were only introduced and didn't go any further than that. Some were introduced, passed, went back, and didn't make it further. And then one or two of them actually made it significantly further than that, and then were then shut down. So I'm going to give you a brief overview of each. The first one, HB 261036. This would have allowed taxes on vacant residential properties, presumably to use those taxes to develop and implement more workforce housing. It also allowed different municipalities to come together and create kind of taxing authorities, joint taxing authorities. It did not pass. Protections for residential tenants. This one was also a housing bill, landlord-tenant bill. And what it spoke of was demands or notices, redaction of information, redaction of eviction cases, unless the parties agree otherwise. Again, I put this in here because some of our associations, particularly our mountain communities, do have tenants or on-site managers that they're renting housing to, for example. So that's why I'm listing this. Homeowner insurance data privacy protections, another insurance bill. This one, however, targeted the protection and processing and retention of consumer data and privacy protections. It also had a component in it that would have required underwriting if they make an adverse decision as to insuring you to provide the reasons for that. It did not go through. And then minimum lot size for subject jurisdictions. This is housing. This would have affected new builds. And what it said, had it passed, is it would have prevented, again, subject jurisdictions, so cities and municipalities, from requiring larger than 2,000 square foot lots for single family homes. We saw a lot of housing bills this year come through. Again, this first slide didn't pass. The next slide I'm going to show you didn't pass. But two of the bills dealt with lot size. Two of these bills did. One, this minimum lot size, and then the other one that I'm going to get to talked about splitting lots. So I think we're going to see those more in the future, just like we've seen the ADU bill a couple of years ago kind of keeps gaining traction, and we're seeing more and more ADUs. This kind of all blends together with that. All right. Also, second slide, these didn't pass. I'm just putting them out there so you know. Preferred language notice to homeowners associations. So currently, particularly when it comes to, we say it a lot with your collection notices, but association notices, the way the law is currently written is that if an owner requests that those notices or documents, if the owner says, I want to receive these in a language other than English, I have a preferred language, then the association has to comply with that. And so they have to provide those notices or documents in that preferred language and in English to that owner. This bill would have required owners to first demonstrate to the association that they did indeed need to receive those notices in a language other than English. They would have had to demonstrate a need for notices or correspondence in that preferred language. And then the bill would have removed the requirement that the notices be provided in both the preferred language and English, and would have allowed associations to just move forward with notices in the preferred language. That bill did not make it very far at all. But it's interesting to see because, you know, every year, and I hate to mention collection because it's like Beetlejuice and it pops up after we say it 3 times. But it seems like every year we're having the like covenant enforcement and collection bills pass, or we talk about a cleanup bill for some of the bills that have passed, or, you know, we have issues that nobody foresaw or maybe did and thought they would go away. I don't know. And so it's interesting that when these come back up, and I don't know if we're going to see those in the future, we will see. Okay, this tenant utility billing. This is a landlord-tenant bill, but it also affects associations. So what this bill would have done is it would have required for new construction that each unit have an individual meter for utilities, for water primarily. Some of your associations, you don't have those, and it becomes an issue, right? Because you're trying to assess everybody equally. And then, you know, the person that's a single homeowner says, well, why am I paying the same as the family of 10? And, you know, blah, blah, blah. And am I watering your lawn association? So on and so forth. So this would have, 1, implemented individual meters for new builds. And then 2, would have allowed existing property owners, so association, for example, to use a ratio utility billing system if it met certain requirements. And what that involved was actually having to take a cut off the top and then billing out for the rest of it. So the association, had this bill passed, would have received a bill for, let's say, water. They would have had to take, I think it was 10 or 20% off the top as a nod to water that may have been used for common elements. And then they could have split the bill and rationed it out amongst the property owners after that. So I don't know that we're going to see this one come up again. I kind of think we will, because this the metered system it's causing a lot of consternation with many of our associations. So I think we are going to see it, at least on the new bills, come up again. And then lot splitting approval. So this is the one I was mentioning on the last slide, another housing bill. So in addition to the bill that if it had passed, it would have required the no greater than 2,000 square foot lots. This bill would have allowed jurisdictions to let people split one large lot into 2 separate lots under certain circumstances. Now, there's more to it than that. Certainly those of you who may have homes that have gone through this know that in a community association, even if the city or the county approves a lot splitting, you still have to amend the governing documents, amend the plat map to reflect it, so on and so forth. But this would have been headed in that direction as well. And again, it's to divide these lots up so that you can create more housing or have, if I have a large lot, I can sell off half of it, and then I can have my home and my ADU and sell off the other one for somebody's home and somebody's ADU, presumably. The next one, private membership club covenants. So this one, for those of you who are in associations that come with, for example, a mandatory membership in the golf course that you're next to, this would have prohibited recording a declaration that requires owners to belong to that private membership club. They would have had to opt in as opposed to be mandated to be in it. I don't know if we're going to see this one come up again. It didn't seem to make it very far, but you never know. And then homeowner, natural disaster mitigation, another housing and insurance bill. This would have made associations and individuals eligible recipients for assistance from natural disaster mitigation enterprise funds. Wow, that was a lot to say. Now, what we're going to see in the future. I think we, from what I have heard, will likely see some type of bill that affects covenant and collection or association disputes in general. It will probably be an alternative dispute resolution type of bill that has popped up twice now and did not end up going very far. So I think we're going to see something like that. We keep hearing talk of cleanup bills for collection and covenant enforcement. I don't know if we'll see that. I think down the road, and probably not necessarily next year, we're going to see a reserve study bill come through, or an investment of reserve bill, or some type of reserve funding. Like I said, this developer one that did pass initially had a funding component in it that was taken out in order to pass. There's been a lot of speculation that a mandatory reserve funding bill would likely be vetoed by Governor Polis. However, as you know, his term is going to be ending, and so whether or not it'll pop up again, perhaps. We will probably again see the lot splitting, smaller lot size bills come in. I don't know. And I am going to tell you on this 2027 predictions, I'm also going to put under the other that we still get a lot of questions about a lot of the bills that have previously passed, like ADUs, like flags and signs, like 30-day cure notices and covenant enforcement. So if you can, I would speak to your attorney or go on things like these webinars that are recorded and refresh, because it seems like a lot of times when the board, we have boards that tend to be the same volunteers over and over, right? And then as the boards eventually change, those new boards come in and they haven't been dealing with this like we have. And so they have a lot of questions, or they go by their documents that might say, only political signs, for example. And we now know, of course, that law is no longer valid. So take a refresher on that. Now, I see we have a lot of questions, so I will try to get to them. And we'll see how we do here. All right. So limited common element. That is going to be, it's designated as a limited common element. A limited common element is a common element that is designated as a limited common element in your governing documents, either in the declaration or on the plat map. You'll look through, it's going to define limited common element. Most likely when we see limited common element, it's going to be a part of the common element that is for the use of only one owner, for example, or only a few owners. So like a patio, a balcony, a patio, a deck, a garage sometimes can be a limited common element. So you'll look for that in your documents. Everyone in our complex is assigned one parking space. There is an open parking space. Can an owner install an electric vehicle, I assume it's electric vehicle charging station, in an open parking space not adjacent to their unit? Yeah, so the EV charging law, which passed, I want to say it was 2022, I could be wrong about that, states that an owner can install an electric vehicle charging station on any parking space that's available for their use, even if it's open to other owners. So they would still, you could require them to pay to install it. And I don't know why an owner might do that. I mean, maybe if they're the only EV vehicle, electric vehicle in the complex, but certainly if there's, 20 of you and you're the owner that paid to install the charging station, it might be being used every time you go to use it. But yeah, you would have to allow it. If you do not have an EV charging station policy, I would get one, or at the very least have your rules and regulations and architectural guidelines updated to reflect that the board is allowing that and under what circumstances. Does HB 261045 apply to things like plants? I had someone say, this is what the question says. I had someone say they were emotional support plants that they were trying to grow in a potted planter garden they installed in their driveway. This specific bill deals primarily with service animals. However, depending on what the request is for the accommodation, I would treat this as a request for an accommodation, and I would speak to your attorney about what you can and cannot request regarding emotional support plants in addition to animals. But HB 261045 was specific to service animals. All right, another one about the assistance animal bill. Why don't they just write the bill clearly saying HOAs can no longer enforce restrictions on animals? I don't know. It's kind of like towing. Why wouldn't you just say you can't tow anymore? Okay, so this question says, I have a few owners inquiring about comfort chickens. That has been a big thing lately, chickens. And by lately, I mean like the last 3 years. I really don't know how to answer them anymore. State guidelines are vague. Can we say no to chickens? I'm sure they do not keep them inside the home for comfort. So it depends. Everybody's favorite lawyer answer. Spend millions to learn how to say that answer. Couple things. One, are they asking for chickens or are they asking for support animals? Because that's two different things. If someone just wants to keep chickens and your declaration, the first place you look is your governing documents to see if they have any restrictions on chickens or on hens or on roosters or on fowl. You also will want to check with the city or county you are in, because some of the cities and counties say you can have chickens. Some say you can have chickens regardless of whether there's a covenant or restriction prohibiting them otherwise. And some just say you can't and you're good to go. The next part of this is, are they asking to have those chickens as emotional support animals? And we have had that. If they are asking to have an emotional support animal, regardless of what type of animal it is, then we're going to have to take a closer look at the documents. If they are asking to have a service animal, the service animals are a little more specific. It's dogs, miniature horses, but emotional support animals, that's a much broader category. So if they are asking for an emotional support chicken, like I said, we've had that. We've had people ask about emotional support animals of various species. That's something you're going to have to speak to your attorney about regarding what accommodation they're requesting, what animal they are doing. It doesn't necessarily matter whether they keep them inside or not, because we don't know what emotional support or what comfort the animal provides. And whether it's a comfort just to have it nearby, or whether it's a comfort to have it inside the home, or whether there's an entire flock of chickens that each one provides individual comfort. So those are all questions that come up when we get these. They are things that you're going to have to, again, you're going to have to be specific about whether it was an emotional support or service animal request, or whether it was just a request to allow this type of animal in the community, then what your documents say, then what the city and county says, and then of course what law says regarding if it's a comfort animal, emotional support, or a service animal. All right. This one is about the Declarant Reserve Study Bill and the turnover of property from management companies. It says, does this bill require the records transferred to be accessible? Many records are downloaded from a software package that new management can't navigate or reformat. So presumably they want them to be accessible. Otherwise, there wouldn't really be a point in turning over the records. What the law or what the bill does state is that you do not have to provide proprietary software. But you would not be able to simply provide it, in my mind at least, in a format that no one can read. So I would suggest putting into like a if nothing else, a PDF or an Excel or something. But it doesn't really, I think it's presumed that they're going to be accessible. And I think that there's an argument that if the records are provided in a way that cannot be accessed, that is probably not going to conform with the statute. But again, there's no requirement you turn it over in your proprietary software. You would just have to turn it over in an accessible format. This person says that they are happy with the HB 26-1099 reserve bill. Unfortunately, it's a little late for them because they've already transitioned out of developer declarant control, but they're working on a plan for expenses now and moving forward. And that is a good time for me to plug the, hey, take a look at your budget talk. Every year we're seeing these bills come through, right? This year, like I said, it was a little less that passed. Last year, I think we had, I don't know, it was like 17 or 21 or something like that passed. But each year, there are bills coming through that affect us. And each year, many of those bills require some type of update to your governing documents. So in addition to budgeting for things like your reserves and common elements and maintenance, repair, and replacement, you also want to budget for redoing, updating, amending, implementing documents, right? It's just the world we live in. I know you don't like it. I'm not telling you that to plug my own business here. I'm saying that it's just the world we live in. Question about that same bill, 45 days from the last day of management or 45 days from the date of notice. So the way that bill is written regarding the termination and turnover of property from the management companies is that it is 45 days from the non-renewal or termination. So I would assume it's 45 days from the date of notice, but I don't know because it's not written very clearly. Does a service animal include emotional support animals? Generally, no. The law looks at them two different ways. Service animals, like I said, are going to be the dogs and the miniature horses. The emotional support animals have a variety of animals that can be considered emotional support animals. Next question is, do we have any idea what the cost of the home hardening surcharge will be? I don't think that the board even knows. The board is yet to be appointed, right? The governor has until January 1st to appoint. So I don't know that they even know what fee they're going to assess. I think that they're going to be in the midst of developing a budget as soon as they get appointed to determine what they need, and then probably start there. And then depending on the demand for grants and other materials, that may be increased, but I don't know. Let's see this one regarding the 45 days for the management company to turn over documents. If the management contracts were signed prior to the effective date, do they have to follow that 45 days, or will they be okay to honor what is in the contract? So the way it's written, it does not. There's not an exception or a provision that would grandfather in, so to speak, the prior management contracts. Rather, it just says 45 days. And so once it's effective, if notice is given after that, it's 45 days from the date of termination or non-renewal. That's one of the things. Sorry. So the next part of this question is, for example, if the contract termination says 90 days to transfer info, is that honored if it was signed prior to the effective date of the bill? I don't believe so because of the way the bill's written. It's 45 days as of the date it's effective. But that's one of the things that's unclear is it says 45 days from the date of termination or non-renewal. Was termination the date the contract ends or date that the notice was given? I don't know. I would err on the side of caution. I would speak to your legal counsel for your management company and get their interpretation. And if you choose not to do that, I would be very prudent about it. Just go with the 45 days. This one, how do the new laws pertaining to Kiowa impact pre-Kiowa communities that never filed with the county clerk that they would be Kiowa compliant? So if you are a pre-Kiowa community, meaning you are a community that was created prior to July 1 of 1992, you are still subject to some of Kiowa, as you know, one of which is the what I refer to as that public policy statute. So you would still be required to comply, for example, with the solar energy bill. The management company, the bill that affects the declarant reserve study, also speaks to the inspection of records, which would apply. And then the portion of that bill that applies to management companies wasn't really a Kiowa. It's inserted into Kiowa, but I believe it's going to apply across the board. So, yeah, Kiowa versus pre-Kiowa. That's always a fun one, isn't it? Let's see. We talked about the plants. All right. Another EV charging station question. If someone installs an EV station in the open, so an open space, a space that's not designated for one person in particular, could they have access to two spaces if they have a deeded space also? I mean, technically, I suppose it depends on how the documents are written, and as to how the deed restriction is on the space. But the way the EV charging station law works is it says that they can install it on a space that they own or they use. So if they regularly use the open space, then presumably they could install it there, even though it's accessible by other people. Kiowa applying to grandfathered HOA. So if an HOA is established in 1984, does Kiowa apply? Yes, to a certain extent, depending on the type of community it is. There are still certain parts, there's kind of a number of different things with Kiowa. We have Kiowa communities that are full and most everything in Kiowa applies. We have some communities that only part of Kiowa applies. We have what are called pre-Kiowa communities, which also means only some parts of Kiowa apply. And then we have Kiowa exempt communities, which basically means no parts of Kiowa apply. So it depends on the community. I know this one you're saying was established in 1984. Certainly there are going to be parts of Kiowa that do apply to it, but it depends on the type of community, the size of the community, whether they're residential, commercial. I mean, there's a whole bunch involved. So it's going to depend specifically on your documents. You probably are going to want a legal opinion regarding which portions directly apply, which portions of Kiowa apply. What is commonly used management company proprietary software? Some management companies, depending on the size, might use, like, they might send everything over in like Word documents in Excel, for example. Some management companies use, like, Caliber is one of the softwares that I've seen management company use. Some companies create their own software that would be akin to something like Caliber, or something that is specifically designed for their individual management company. That I could think of a couple management companies that have them, that they had it designed for them for their use. So it's not one that's available to all management companies. It was one that was specifically designed for that individual management company. That would be considered a proprietary software, meaning it's theirs, that they're the only ones that use it. With the new solar panel law, the board is concerned about the roof's structural ability to support the weight of solar panels and the insurance requirements for solar panels installed at the townhome community. How does this new policy affect the HOA for their concerns? So this new bill is about portable solar energy devices. So they are meant to, they're the type of panels and the type of system that's designed to be able to pick up and go. Now, it might take a couple of you to pick it up, but it's not the large solar panels that have to be mounted on the roof. Rather, it's the ones that you can literally set out on the deck or the balcony, and then they can feed the home or the meter with the energy, so you're not using your normal grid energy. So it's not going to, these portable devices don't have the weight that the full panels do. They also do not require, unless you would like to require them, they don't require them to be mounted permanently. Although, like we said, the bill certainly would allow you to do that if your association wanted to. So I think if you have a community that's worried about the roof structural ability to support the weight of the solar panels, then this is probably a good alternative for that community, because you're not going to be placing all of these panels on the roof. All right, I'm looking to see if we have any other questions. We have 6 minutes, guys. So I will wait here for another few minutes to see if you have any other questions. If you do, or you are like me and you think of them after you leave here, my email's on here, aashley@altitude.law. You're welcome to email me questions. I will answer them if I can, or I will get them over to someone who can. And then certainly feel free to, like I said, reach out, have some legal opinions if you have questions about Kiowa, if you need your solar panel policy or rules and regs reviewed, reach out to your legal counsel on that so you can make sure you're in compliance, because as we know, it costs more if you are found to be non-compliant later than it did to do it right the first time. All right, everyone. Thank you. Thank you for coming. We have a couple more questions. The 45-day turnover requirement, is this available for pickup or the new management company to pick up? It just says you have to provide them, that the association or the management company has to provide them. It doesn't state that you can require them to pick it up. You might be able to, I don't know, but it just says provide. So I would err on the side of provide. The class is being recorded and will be posted within 24 hours. That's the wizard that said that. That's Courtney. I didn't know that answer. 24 hours. You're welcome. Otherwise, I could see some of these names on here that are very familiar. So I'm glad you guys were all able to attend. And I think that's it. Everybody have a great afternoon. Let me know if you need anything. Thanks for coming. Bye.